First, let me say thank you so much for having me here. It's an honor to be here at FGV Sao Paulo at its reopening from COVID. I was supposed to be here 2 years ago. It was 2 days before the Brazil border was shut. So again, it's an honor to be back and to see the time lapse of innovation at FGV and Brazil in general between 2 years ago and now, which is extraordinary. That is a great question, and it's a profound one, and I'll try to answer as best I can. I do see it's not just that legal innovation sometimes is a more surface level than it is deep. It's also that AI is also exaggerated. So the term artificial intelligence is itself kind of a marketing term that early computer scientists used to try to distinguish and get people excited and get funding for very important computer science work. And to some extent, it backfired. Artificial intelligence, initially there were grand excitement and project in the 1950s and 60s and then 80s. And then there was something called the AI winter, the artificial intelligence winter, where the marketing or the hype exceeded the reality of what had been possible. Now, that's reversed a little bit, and you see terms that are more technical like machine learning, which is essentially statistics, operationalized math over law, and neural networks, things like that. This is all AI, but they're using practical terms that define what it's actually doing inside. In law, it's very similar. And I think there is a great push to do innovation and to be innovative, and that a lot of that force is coming from the outside. Clients want lawyers to be more efficient. Lawyers can be very resistant. We're perfectionists. I love being a perfectionist, but we're very resistant to change because a lot of what we do as a profession is looking backwards. That looking backwards in the traditions, which is bountiful and good, has led to a cognitive error where we're failing to adapt and evolve in the methods of the ways we fulfill those traditions and the traditions of the law. So I do see when law firms are pushed by their clients to be innovative, they create labs, they create special positions, but a lot of times the people that are created in those positions, they're isolated, they have their box, they're doing, you'd call them toy projects, but they don't fundamentally change the way corporate transactions, mergers and acquisitions are done. They don't change how litigation is done. Contrasting to that, you see people who are really doing the very, very heavy work of improving output, improving client outcomes in certain areas. And I'll give you an example. In patent law in the US, almost everyone, all the big firms now are using artificial intelligence and empirical data to say, okay, I'm filing this case, I'm in front of this judge. She has granted every motion of this type and denied every motion of this type. I'm going to use this argument to try to win cases. You would not want to practice intellectual property law at an elite level in the US without using empirical data. And the only reason we have empirical data is we've used AI to automate the reasoning that is required to extract those data. Same thing with the judges. The judges can now see how every other judge in the country has defined a term that's similar to the term in their patent. They're not bound by what the other judges are doing empirically, but they can see what they've done, how different judges have handled it, and what happened as a result. That makes their jobs 10 times easier because they don't have to start from scratch and reinvent the wheel every single time with a very technical case. So those are two examples in litigation where AI has been very transformative. And while it was easier to do in a field that was open to technology, a lot of engineers become patent lawyers, so it was a little easier to innovate there. The same technology is now scaled to every other type of case. And so that's an area that's been very productive. Contract AI, the analysis of contracts at scale. Large companies will almost always use some form of automated analysis. It doesn't replace lawyers, it just scales them. So the same junior lawyer or junior analyst can review approximately 8 times as many contracts as she could before. If you can be 8 times faster and actually more accurate, you're committing malpractice if you don't use that type of technology. It's an advantage and a disadvantage to be operating in law. When we were trying to convince leading computer scientists running the AI lab at Stanford and others that law was fun and that they should spend their time on it, which was difficult to do. They're very busy, they wanted to say no. One of the ways we did that is we said natural language processing technology, which is another branch of artificial intelligence and computer science. Natural language processing had, especially at the time, failed or was very poor actually at interpreting language and being able to generate language and create chatbots and things like that. So the NLP performance was very poor at the time. And we said, lawyers are essentially unnatural language processors. We are ourselves natural language processing machines. It is what we do. We craft and we architect using Brazilian Portuguese, English, German, Mandarin, whatever it is. We use natural language to craft things that are really almost like engineered systems. And so that formality in the language, while it might be a disadvantage to a consumer to read a very long document, it's a huge advantage to a computer who works in very formal ways and has an infinite amount of sort of speed and time, if you will. So that formal structure actually enables us to do more and perform better with existing artificial intelligence tools than we could in newspaper clippings or TikTok audio, things like that, because of the formal nature of it and because of the formal box that we have around certain legal documents and writings. It's a disadvantage in this sense. Law is not really data. Law is an abstract modeling system that exists in relation to text and data. The legal state of a human, whether he or she is guilty or innocent, whether they owe taxes or not, whether their rights to their consumer data have been infringed by a commercial entity or not, whether the judge has to grant them a right to be heard on something. These are formal structural things that exist in their state. They're related to texts that exist, their own documents, the Constitution, statutory laws, codes, and now increasingly in Brazil, common law. They're related to that, but it's something different. It's something abstract apart from pure data, text. So engineers will often come in and they'll treat law as just pure raw data, and very often they will run into a ditch because they're not extracting the real legal state. They're just processing data and treating all data the same. And so that's both the benefit of legal language and some of the disadvantage. The last thing I would say on that is you can bifurcate or separate the formal structure requirements and then create a layer, an interface layer that's designed to help understand and communicate and maybe even visually understand legal systems. Those two functions can be different just as they are in software. Whenever we use Google's search algorithm, we see a simple bar in a box. We do not see 12 billion lines of software code every time we click the button. And there's something to be learned from software there. I still think when we were starting Lex Machina at Stanford in 2006 and onwards, the hardest thing for me to do was to recruit people that could read and write well. Read, write, and analyze. So the core skills of the law, I think, have not changed at all. You still want to be expert at that, reading, writing, and analysis. You don't have to become mathematicians. I think two skill sets that are useful are, one, understanding empirical data and how it's related to the law, and second, the ability to translate If you know something really, really well, you can translate it to someone who is not from your domain. A child, or an adult, they could be an engineer, they could be an airline pilot, someone who doesn't necessarily know the law or care about the law, you need to be able to translate that for them. Not everyone, not all the time. You can have lawyers that are just doing exactly what lawyers have been doing for 2,000 years, but you will also need other lawyers that can connect that activity, that engine of text, into the rest of society, into economic data, financial data. And I'll give you a couple of examples. When I was at General Counsel, I worked at in one place for aerospace engineers, very, very great aerospace engineers. And they thought of everything from a really quantitative and analytic perspective. And they said, we want to know why we have to, every dollar we are spending for law, every dollar, every bit of time we are spending on legal function, we need to know why. What is the return on investment for filing a patent, doing this compliance work? And in some cases, I could say, well, you have to do arms trafficking control compliance because you could go to jail if you don't do that. So we have to do a training. We have to do HR policies because A, it's the law, both national and state. And also it's terrible if people can't be themselves in a workplace, if they're harassed. And they got that. We were very good at enforcing all those things. But in many cases, I had to say, if you don't file these things, you will be facing a patent lawsuit of roughly this dimension in 2 years. And generally we'd be right. So, and we'll show them data to prove that. So you can't just say, this is a good thing to do, you must do it. You have to say, here's 50 lawsuits. These are companies just like ours, and this company lost $1 billion or $200 million. They were enjoined, they couldn't sell their product, company was destroyed. You give them use cases. You don't exaggerate, but you say, here are the data. And showing them data is transformative. All of a sudden, an engineer can, now I understand. They can put it in their graph. You don't want to dehumanize or oversimplify the law, but you do need to start showing data. Another example, great tech company with an amazing general counsel's office said, I know this lawyer is really, really good. I know she's great. But I can't convince my accountant, my controller that runs over the legal department to hire her because she's 5 times more expensive, or twice as expensive as the next lawyer. And so we got data and we gave them data to show that this lawyer, in all of her cases being complex and different, but in similar types of cases, was about 5 times more effective than these other lawyers, who also had a great reputation, but lost a lot more in their cases. So they were able to hire that lawyer because they could show the return on investment, despite the higher hourly rate, was much higher. And people were, they were aware of this lawyer and they didn't want to go to trial with that lawyer. So cases settled faster. So if you can show data to engineers and accountants and people outside their domain, you're much more powerful and much more convincing, and you're going to be more successful at working with people outside of a purely legal environment. The third example I would give is when we were starting, we were showing a very technical legal empirical data set to the country. We were just releasing the data. And my goal was for my 8-year-old daughter to be able to understand what was happening, the data we were showing. And thank God we were able to do that. We created a heat map that showed litigation patterns in the United States. They started here, and then over time, all the heat went to one spot. There's something off in our system. Just like there's a heat spike in a helicopter or a car, that means there's something wrong. So if you can explain it to an 8-year-old, even a interested 8-year-old, or hopefully a disinterested 8-year-old, if you can explain it to an 8-year-old, you're going to be more effective in life. It will require you to master the material. And lastly, I would say, when you can explain something, it's hard to explain the law to a non-lawyer. It's much harder to explain it to a computer, which are much dumber, right? They don't understand common sense. To explain the copyright laws of the US to a machine, you have to master it. And so one of the things we found at the university was that if we did a workshop on, say, copyright law, which is one of the ones we did, or human rights law or civil law, it forced the students to schematize and understand the law much better than they otherwise would. Because again, they have to explain it to a machine, which is very hard. So just like they say, if you want to learn something, teach a class on it. If you want to understand just the law, just the code, try explaining it to a computer, and it will teach you both the law, the statute, and the common law, increasingly in Brazil, but also how to do that translation empirically. So I think there are books out there on legal AI is hopefully helpful, and I mentioned some other documents and text in there. Patricia Peck is also writes constantly, and others, and Marina Pfefferbaum and Alex Pachenko I'd recommend as well. But you can start there. The most important thing, though, is to do a project. You will learn at a hyper-accelerated rate if you build something, if you try to do something that's using the text and using the law, but actually trying to help someone. It's a profound question, and one that there is no clear answer for, perhaps, other than the answer that the Brazilian public decides. And the reason I say that, we were just discussing this exact same question with the Secretary General of the STJ, the non-constitutional Supreme Court, yesterday. How do you structure that data? How do you choose between open and closed? Again, there is a spectrum, and I think it's más complicado, extremely complex, how you set up that infrastructure. Going back first to the history, the International Criminal Tribunal for Rwanda was a private database for a public institution. And the reason our database was private is, one, we had people that there were criminals that we were tracking, so we couldn't release that data. It was in the prosecution's database. And second, we had to protect people. So we had to interview people that were coming in to the tribunal. Just talking with us, they could be killed. So it was very dangerous and very important for us to protect them. We had rape victims who in particular were at risk. They were in witness protection. So we had to be incredibly careful to protect our data, even though it was for a public purpose. And we were extraordinarily careful with that. Even some of our investigators, if they learned certain things, they could be killed. And they could very much be at risk. So incredibly important to protect that and make it proprietary. But then at the end of the day, eventually when it gets to the prosecution level, that data becomes public. And it's more public than anything else. It's public common law. The conviction of Prime Minister Jean Kambanda, who was a key person in the genocide in perpetrating it, that is all public, and that precedent is being used by the world, much like a patent can be cited by another patent official. And heads of state are, again, now they can be subject to criminal prosecution for violations of international criminal law. But the data set was actually private. The data set with the IPLC, the IP Litigation Clearinghouse, there were public data, but those public data were not useful yet. It was almost like having raw atoms or raw metal on the ground. Titanium, carbon, bits of plastic, all kinds of things, and it was very impure. It was coming from different bits of data, different things, and some of the things had to be mined. They were deep under the earth. So there is almost a spectrum of raw material all the way through to a flying car. So to make something useful, there can be an almost infinite set of processes that you have to engage in and complete before you can build something useful. The beautiful thing about data, because it's not pure matter, it's pure information, you can reuse that data an infinite number of times. So one person can use the data to build a flying car, another can use it to build a terrestrial vehicle, another an airplane or a house. And different parties can use that data set for different things. It's the magic and the economies of scale of software and data, legal empirical data. In the U.S., the federal judiciary charges money for each copy of an actual document you need. Some data are public, they charge. The consensus, I think, in Brazil is that people want to release this data for free. But that doesn't actually answer the question that you posed. And the reason is, when you release raw data into the wild, to make it useful requires work. And who's going to do that work? It might just be rich people who are selling that data for lots of money to other rich people. It may not be the citizens' rights groups or, the majority of Brazilians who need access to something about consumer law or public health care, or which lawyers are good and which are crooked, and we have them both. Everywhere in the world there are crooked, venomous lawyers as well as ones that are pretty dutiful and competent. And so finding the good and the bad in that state of matter is incredibly complicated. The real question is, who's going to do the work and how do you provide those human resources? Because when I asked the STJ judges what their biggest challenge was, they said it was human resources. So we have data, raw data exists, or at least it's going to be collected. So you have images, essentially, of decisions and documents and filings. Some of that has to be protected, and a lot more has to be protected than people think, because you've got big data. So big criminals can take that big data and find people that can be exploited. They can find people that are in trouble and attack them, try to defraud them. It happens all the time in the US. And they can look at financial data and try to predate or target individuals just from the raw public data. So you have this raw data. How do you do the work? We were charged quite a bit. Initially at Stanford, at the university, each judge decides what happens to her or his data set. So many judges did not want their data sets released. One judge we had to argue, we had to fight in front of him, and we eventually, thank God, won. It was Vaughn Walker in the Northern District of California. He was an alumni, but the reason he did it was because he loved the project we were doing, and he wanted us to do more. He wanted us to help improve the criminal law system and the habeas corpus analysis system, how prisoners deal with their rights, both for the good of the judges and the good of the prisoners, and life and death issues. So who is going to do the work? How does it get paid for? And how do you help the poor, not just the wealthy? And help both of them, actually. And the way I like to think about this is keep some data internally, release other data right at large and make it as broad as possible. The United Kingdom also has a very good model and is very efficient at releasing litigation data. But none of that really matters. What really matters to me is the return on investment, ROI. How many lives are you saving? How are you growing the economy? Who are you helping? What is the object that you're trying to accomplish with this data? You can't have a religious view about everything is open or everything is closed, because what happens is if you open up everything, it may be that only certain groups get access to the data, even though it sounds open. What you have to do is figure out, what's the objective of releasing this? What are we trying to accomplish? And how not only do we release enough data, but how do we make sure that the work gets done for that? So in some commercial spaces, that gets done automatically because there's a commercial interest, people will fight it, people will create startups. In other areas, prisoners' rights, you may have to fund this. And so the important thing is not just the data ecosystem, it's how do you accomplish the goals of the nation state and still remain true and practical about getting the work done. Anyway, a very broad, difficult question. Again, it's something that we grapple with every day. We were just grappling with that exact problem in class a few minutes ago. with Professor Pfefferbaum and Professor Pacheco. I love the innovation happening. What I'm wary of is labeling it that right away, because you get an immediate reward. If you say, I have an innovation center, you're immediately viewed as more innovative than others. I would rather underpromise and overdeliver. So I love the innovation, but I would almost rather call the workspace, hard work room for improving mergers and acquisitions outcomes, or hard work room for assisting civil rights complaints, or workroom for improvement of judicial analysis. Again, two reasons for that. One is it's often better to underpromise and overdeliver. Second, and this is a problem in Silicon Valley, we can fall in love with our own technology. The words computational law and legal informatics and all these things, they're very lovely and they sound very good to your ear like a lovely song, but who are we helping? If we're not focused on helping a human or a group of humans or an archetypal user of some kind, it could be a judge, right? And that's a great way to help a country, is to help an official of some kind. If we're not focused on a human, what are we doing? And so technology can be a little bit of a siren song, and we can fall in love with it. And when we fall in love with it, we forget that it can cause damage and harm as well as, and we see this in social media all the time. What is the benefit? Who are we trying to help? And how does it work? And so I love the reality of that. I'm very wary of the nomenclature. And talk about this in the book a little bit. And we say pretension is the thief of action. If we're focused on a client, if we're focused on a case, if we're focused on a specific outcome, it's very, it charges us to do that. It could be life and death, or it could be just helping someone through a difficult time, or making sure that a right is perfected and doesn't go off the wires, or that a merger goes through. If you're focused on a very specific outcome or case, it concentrates the mind and helps us, and it motivates us. Saying, I'm innovative, it actually can sap your energy to actually do the innovation, and that's what I worry about. But it's a big debate. I may be wrong completely. Others have said it should be part of everyone's title. But I would rather underpromise and overdeliver. Thank you so much. And as it happened, Judge Fabio at the STJ yesterday asked the same question. And this was a judge, by the way, who is doing this. He's one of the leaders of the CNJ's operation in this area, where they've got, I think, 61 to 64 different projects. And I think one of your sister schools has done audits and analysis of these things. There is an enormous amount of activity. It's almost like a Cambrian explosion of life in these areas. It used to be a desert, and now it's blooming with an incredible amount of activity, and I hope it continues. Brazil, in my view, is poised, or is at a point where it can become the leader in the world for employing and using legal AI and legal empirical data platforms more efficiently than anyone else. Why do I say that? Both in Sao Paulo, in the area right around FGV, in your sister schools, in Rio and other places, there's an enormous amount of legal entrepreneurial activity, not just around law, but it's around insurance, right? The insurance laws in Brazil have changed. Again, I can't evaluate whether it's good or bad, but people are very excited about the changes in finance and insurance law in Brazil all over the world. And they see it as being better than the American laws. Why so many new banks have been created in Brazil very, very successfully. There's the company Brex in California, started by 2 Brazilians. So there's an amazing amount of foment in the entrepreneurial community in Brazil in general. And I think the culture is an amazing addition to that. It's very powerful in and of itself, in terms of people being able to do these things and having the courage to do these things. there is no answer to what will happen in 10 years. We could completely fail. We could run off the road. It's up to us. We make decisions every day to do that. And what I said to your students an hour ago was, no one else is going to do these things. You have to do them. And I was specifically asked, well, the rich projects, the big commercial cases and things like that, those get taken care of because there's commercial interest. People invest to make money. The market can help solve some of those things. What about regular citizens? And I said, you have to build them here. You have to build citizens AI, and no one else is going to do it. No one's in a better spot in the world or in time to do this. And this time of change, this time of possibility, it's not going to last forever. So the next 10 years are where we should leap into action. It's not determined what will happen, but I think Brazil could lead the world. And I think you're right at the center of that. And every student here, every member of the faculty, every member of the media and administrative team is exactly part of this story.